To understand the fallacy with the argument that was made in the Byron Allen racial discrimination case, Comcast versus Entertainment Studios, you must first understand the concept of the motivational factor, the element of the argument argued by both sides in this case, and must understand the quintessential importance of representing your side of the argument. And by not laying down a proper argument will, in fact, allow a judgment to be rendered based on what type of argument presented. This is why lawyers are known to be very cunning and untrustworthy, and plain old disingenuous, because they know how to argue in circles, mixing words together so that it can mean something completely different, describing an entire different reality. This is why their services are so expensive, because anybody can pass the bar, but not anybody can litigate. And when you are in direct combat with these con artists, wordsmiths, then you better either know what you are doing or have somebody in your counsel who does. I remember when I represented myself in an administrative hearing case against one of my former employees some years ago, how I was able to defeat a multi-million-dollar security company by sticking with the California Civil Code, and how the company tried to use that same civil code in a completely different manner. They fired me for sleeping on the job, but I was asleep on the job during my lunch break. This company used this as an opportunity to let me go, and when I filed for unemployment compensation, I was warned that the company had a long history and an undefeated record of nullifying those benefits at hearing decisions. Well, they finally met their match. This company argued that the California Civil Code that gives employees the right to take a break was nullified and void in my case, because I signed away those rights under contract. I argued that I signed it under duress to keep my job, and that forcing employees to sign away their rights in order to keep their job falls under duress. And this duress clause is, in fact, will make the contract in itself null and void. This is why arguments are important, because technically the company was correct. I did sign away my rights, but also technically I was also correct. Forcing me to sign something in order to keep my job is illegal. If I would have made a different argument, then I would have lost, even though I was correct. For example, if I would have argued that I did not know that I signed my rights away, then at that point I would have been wrong, because ignorance is no excuse for a violation of law or legal contract. I say this because in Byron Allen's case, his lead attorney argued his case the wrong way, and in this historical loss in the Supreme Court, it created a precedent, making it harder for millions of blacks who descended from American slaves able to sue people, companies, or government entities who violate them in racially discriminatory practices. Erwin Chemerinsky is a white man, and he is also Byron Allen's lead attorney in this legal dispute. The Supreme Court unanimously decided that the but-for factor rests on the shoulders of Byron Allen, forcing him to establish the preponderance of evidence that racism was a sole factor and not only a motivating factor. But this but-for factor in deciding if the defendant was racially biased against Allen is unconstitutional. The 14th Amendment has a full protection clause that gives blacks who descended from American slaves full protection of equal status in America. And the Civil Statute of 1866 defines only one part of that protection. And that protection is to protect us in conducting business adventures with white Americans. But the 1866 statute could not exist without the binding of constitutional law. And the specific binding of that law is the 14th Amendment's full protection clause. Discrimination in any case is illegal. An action is either illegal or it is not. I cannot commit a crime and argue that I did not cause damages because the sole purpose of my crime did not focus on the motivational factor of committing a crime. In civil suits, damages does not only equate with breaking the law. If two people collide in an intersection, does not mean that either one or both parties broke the law. However, whoever is proven to be most at fault will have liability and damages. But if two people collide because one of the two parties drove through a red light, then that becomes not only a matter of compensating damages, but criminal activity as well. The violation of the 1866 civil statute under the 14th Amendment is a criminal act that requires compensation. In this case, the motivational factor has flexibility. It does not matter if the motivational factor is 1% or 99%. Just like with the violating the traffic light example, the defendant cannot tell a judge or jury that he is not responsible for compensating the plaintiff who sued because he lacked the sole purpose of running a red light. The plaintiff is not burdened with the but-for causation clause because a crime was committed. It does not matter if the defendant's sole purpose was to run a red light or not, if he did it by accident without intention or not. He broke the law and damages were created. Proving if running a red light was a sole purpose will only create a harsher penalty, perhaps even jail time, but not having sole purpose intent does not exonerate him from judgment. Breaking legal statutes are crimes. Byron Allen's lead attorney did not argue this fact. As a matter of fact, he argued that the motivational factor should get applied in a very inaccurate way in relation to the case. That the motivational factor would have the effect of forcing Comcast to prove that race was not the sole purpose in discrimination. Now just think about that for a second. According to Byron's own lead attorney, he gave Comcast an escape route with the ability to prove that there were other factors outside of race. By allowing Comcast to prove that race was not the sole purpose is the key, because not the sole purpose means that Comcast can prove that there are other purposes, which according to the 14th Amendment would not matter. But by giving the defendant this option, leaves room open for them to give other purposes and reasonings for discriminating against Byron. The white lead attorney could have easily set a precedent in arguing in front of the Supreme Court that racism is a crime and that it breaks legal statutes. But he allowed the defense to litigate the matter as if it was a victimless civilian abiding dispute. Perhaps by being a white man, Mr. Chemerinsky did not want to indict himself, because holding a legal standard as such would permit his own convictions. Perhaps he is a racist himself. Who knows? But what we do know is that the case was argued incorrectly, making it harder for black people to sue racist white people. And what we do know is that sometimes lawyers make deals with each other behind closed doors. And you have a black man suing a white-owned media company in a civil lawsuit that will get talked about for centuries to come. So there is a motivational factor for white lawyers to try to block such of a historical opportunity to make it clear that racism is not just some victimless civil suit matter, but a crime. This is presidential candidate Deon D. Jenkins, the only reparations presidential candidate, the only Black Agenda priority presidential candidate, and I approve this message. Thanks for listening.